Good afternoon. Welcome to the First District Court of Appeals sitting at the Florida State University College of Law. We have one case on the docket today. It is Logan Torbett versus the State of Florida, case number 24-1393. Mr. Upperman, you may proceed when you're ready.
Good afternoon. Michael Uckman on behalf of the appellant Logan Torbett. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
I'm hoping to focus my time this afternoon on the first issue raised in the briefs, but I'm prepared to answer any questions that the court has regarding the remaining issues. The first issue concerns whether the trial court erred by denying the defense's request to introduce reverse Williams rule in this case. Before I get into the underlying facts, both of the charged incident and the reverse Williams rule incident, let me just reiterate what the standard is for reverse Williams rule. I think the 3rd DCA did a good job recently in the Posey case of explaining what a court should consider when a defendant wants to introduce reverse Williams rule. First, the defendant has to be alleging that someone else is the one that committed the crime. And if that is the theory of defense in the case, then the standard is simply, if that other person had been on trial in this case for the crime, would the state be able to introduce the Williams rule evidence? And I submit, in light of the facts of this case, in light of the facts of the Williams rule incident involving BB, that there's no question that the state would have been permitted to introduce, if they were charging Mr. Pruszynski with the Williams rule evidence regarding BB, especially in light of the modified standard that applies to sexual battery cases in Williams rule.
Well, counsel, let me ask about that quickly. I saw from your brief that you're primarily basing this argument on paragraph 2C
Yes.
of 19404 because it does have a different standard. But my reading of that section shows that it specifically applies to the defendant's commission of other crimes. So why is it that we should apply the statute to Williams rule regarding somebody other than the defendant?
Because, well, A, that's what the Supreme Court in the 3rd DCA, repeating that in this Posey case, said is the standard to be applied. You simply
In
ask,
a 2C case?
you simply ask if the state was introducing, if it had been the state trying to introduce the evidence, would it be
Right,
admissible?
let me make myself clear. That is the standard rule for 9404.
Sure.
Okay, but your entire argument is on the special standard in 2C. And 2C relates specifically to defendants.
I
So
understand.
I do not see that 2C is available to get in evidence of crimes committed by somebody other than the defendant.
Well, if you were to hold that way, then you'd be saying that the standard that both the Florida Supreme Court and then the 3rd DCA just said in Posey applies to the reverse Williams rule cases doesn't apply if it's a defendant.
Well, it's a different statute. And if you are trying to get it in under C, which you specifically are, then that standard doesn't, it applies. I'm not disagreeing it applies, but who does it apply to? Whose crimes does it apply to? I don't see that it applies to anybody other than the defendant.
Well, strictly applying the standard, you ask if the person that the defense wants to introduce the evidence against had been on trial, then in that situation, that person would be the defendant.
Okay, so we can consider this under 2A then? and
Of
not
course.
2C?
And it's not
Did
limited
you
to
argue
2C.
Did you make that argument? That this
Sure,
is-
I think it's argued that it's admissible. It's admissible because it is similar. I've certainly said several times in my brief it's similar enough. But without question, if you apply the relaxed standard, it would come in. There could be no doubt
What
about
do you
that.
consider the relaxed standard? What is the difference between 2A and 2C?
The relaxed standard now is in a sexual battery case, and I know this court has seen this in hundreds of sexual battery Williams rule cases. I've certainly seen it in my practice. If the state alleges a sexual battery, the state can introduce any other evidence of sexual nature, regardless of whether it's similar, and regardless of whether it's even being offered solely for the purpose of propensity. Now, in this case, it wouldn't be just for propensity.
Right, so
It's modus operandi.
the way I understand the statute is under 2A, all it says is that it has to be relevant to prove a material fact and issue, which
Yes.
is another way of saying relevance, and it gives a few examples.
Sure.
And what it specifically says is there are 2 exceptions. It cannot be admitted for bad character or propensity.
Correct.
And then you have C, which says that doesn't apply, which to me means explicitly this is admissible for bad character or propensity. That's
Correct.
what C does. If C applies, That's what C does, is it means you can admit it for propensity or bad character. But I don't see that other than that difference, that there is any difference between A and C. There's no relaxed standard about what type of evidence is admissible. It still has to be similar.
Not
enough for
strikingly similar,
admission.
though.
It has to be similar enough for admission. And I don't see, in other words, I see the only difference as the difference in what it may be admitted for.
Well, again, I think it would come in under either standard, and it's not propensity in this case, it's clearly modus operandi. But as far as how the state's argument in its answer brief is that this was not fingerprint evidence. This was not strikingly similar. And in this court's decision in Wisby, this court specifically said, look, it doesn't have to be strikingly similar, but in the sexual battery context, it's similar enough. I think there are strikingly similar characteristics here. That's certainly what was argued below in the initial attempt to get this in. So let's go into some of those. The underlying incident in this case involves 4 people. It involves my client, Brad Pazinski, Jillian Denier, I think is how you pronounce her last name. If I'm pronouncing that wrong, I apologize. And TB, the victim in this case. The facts are that Mr. Pazinski and my client went over to the 2 roommates' apartment. They're all local college students here in Tallahassee. Mr. Pazinski made mixed drinks. The women drank those mixed drinks as well as some shots. And from that point forward, TB at trial said she doesn't have much memory as to what occurred thereafter. She certainly has no memory as to the sexual battery incident that's the subject of the charged offense. She does remember that my client attempted to kiss her and attempted to digitally penetrate her, and she pushed him away. The record establishes that Mr. Pazinski engaged in oral sex with her, also against her will, but she has no memory after that. Mrs. Denayer, she also has very little memory. Her testimony was not helpful at trial as to what occurred, although she does admit that she had consensual sex with both my client and Mr. Pazinski. Mr. Pazinski is the star witness in the case for the state. He is the one that says, yes, there was oral sex between me and TB. Yes, I engaged in consensual sex with Mrs. Denayer, and then I went into a bedroom and I saw Mr. Torbett and TB in that room having sex. That is the most important testimony that the state introduced to try to implicate my client as the one that did this. After the incident, TB had thrown up on herself and vomited, and my client left the apartment, and it was Mr. Pazinski and Ms. Denayer who took TB into the bathroom, put her specifically into the tub, and rinsed her off. Now,
why aren't those 2 facts enough to say that the trial court did not, clearly err here under the abusive discretion fan? The fact that the victim was vomiting and the fact that 2 people put her into the bathtub, those seem to be quite different than the other case you're trying to get it admitted here under the first issue.
No, well, so carry it forward. Let me explain what the facts are for BB, the reverse Williamsville incident. The reverse Williamsville incident occurred less than a year in May. The first incident was July. So in May of 2019, the evidence that was proffered throughout the record in this case was that BB went to Mr. Pazinski's apartment. She was given 6 drinks. She was then taken to the bed, and he forcibly had sex against her will. She cried the entire time to try to get him to stop. And then most importantly, immediately thereafter, he directed her to get up, told her to shower. Why it's important, whether it was his intent the first time, and we don't know whether it was or was not, but what happened out of that, after she was in the shower, after TB was in the shower and she was rinsed, he then texted his father days later, and he said, DNA evidence came back, doesn't implicate me. He learned at that time that by rinsing a victim, he can erase the DNA evidence that would implicate him.
If he learned at that time this attempted method of eliminating the DNA, then why could it have been the same motive the first time around before he learned it? If you're saying he learned about this effect of the bath between the 2 incidents, how can we say, okay, well, he approached the first incident with that same mindset?
But the act of baiting her to eliminate DNA, and the fact that that happened, and then the fact that he did it again, shows that he's the one that's doing this. He is the one that's actively engaging in baiting her.
Just to clarify, this collateral act actually occurred after this incident.
Okay. 10 months later, that's correct. So this is classic modus operandi for someone who, yes, he's directing her, and it was asked during the trial by defense counsel several times, why not just take her to the bed? And no, we took her to the bathtub to bathe her, to rinse her. So now he's eliminating all the DNA evidence, and he knows that because that's what he texted his father days later.
So I want to ask you, because your time is about to expire into your rebuttal, about the admission, and you contend the trial court abused its discretion in admitting the text messages. Are you claiming there was error by the trial court in failing to hold a 92.565 hearing or failing to comply with the requirements of that statute?
No, that's not the argument that was raised. And frankly, I'm not focusing on that argument. That's a tougher argument. I would concede today that there is circumstantial evidence regarding corpus delicti that would seemingly allow that in.
Okay, fair enough.
Again, I think my focus is on reverse Williams rule. And this, again, going back to the standard, if this had happened and Mr. Pazynski had been in trial, of course he wasn't because the state gave him immunity, the state would have been able to introduce this incident involving BB at his trial. There's no question about that. It couldn't become the feature of the trial, but it's relevant. It meets the standard under 9404, whether you're looking at 2A or 2C. It certainly meets the relaxed standard. It's similar enough based on these circumstances, college-age girls, getting them drunk ahead of time, having them bathed afterwards, that this deprived the defense of a key argument. What Mr. Jansen was able to cross-examine Mr. Pazynski on during the trial was simply, was there an open investigation involving another woman? That's all the jury heard. How much stronger would the defense closing argument have been if, look, ladies and gentlemen, after this incident, he bathed her. And then he texted his father and said, no DNA evidence. And lo and behold, after he's offered immunity, 10 months later, he does the exact same thing to another college-age student. He gets her drunk. He sexually batters her against her will, and then he directs her to bathe. And the evidence is crystal clear. When the police arrived, she was in a towel. She was befuddled. And then she later told him exactly what occurred in that case. And the jury didn't get to hear any of that. And there's no question if Pazynski had been on trial in this case, the state would have been able to introduce all of that. That denied the defense their key evidence to back up their theory that Pazynski is the one that did this. He's the one that should have been on trial in this case, and look at what he did just 10 months later to prove that he's the one that did this. Even, you can step aside and if you're applying the relaxed standard, the whole bathing thing, all of it would come in under a Williams Rule incident regardless. Even if there had been no bathing, the state would still be able to introduce, in a Williams Rule case, applying the Posey standard, the fact that he did this to someone else 10 months later. Temporal timing is not an issue with Williams Rule. Whether it occurred before or after, the state has the right to introduce it during that trial. So this would have come in without question if the state had been the one to charge Pazynski. And if that's the case, it should have come in as reverse Williams Rule, and there can be no question. The state doesn't even argue that it's harmless. There can be no question it wouldn't be. Williams Rule evidence is extremely powerful evidence. That's why in the vast majority of the cases you have that are sexual battery cases, the state tries to get Williams Rule evidence in. There's actually a case that says it's harmful error against the defendant if improper Williams Rule evidence comes in. The same should be the case here. If the reverse Williams Rule evidence is left out, that also should be presumed to be harmful because of how powerful this evidence is. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you. And Madam Clerk, since we asked a question into rebuttal, please add an additional 2 minutes onto appellant's time and do the same for the state's time. Thank you.
Good afternoon. May it please the court, my name is David Welch and I represent the state of Florida in this case. I guess I'll start with the first issue here is when you look at the facts of this case, not only does it not qualify for reverse Williams Rule evidence, which, well, counsel cited a case out of the 3rd District, directly in my brief that cites the Florida Supreme Court that said it's the same standard of similarity as regular Williams Rule evidence, and that's from Huggins and Savina. It's not even really relevant in this case because of the situation where we have a group. We have 2 men, 2 women at this.
Counsel, let me interrupt by asking the same question that Judge Winokur asked of Mr. Upperman, and that is reverse Williams Rule evidence ever admissible under 2C1? because of its explicit reference to the defendant in that statute.
If it is ever admissible, I mean, I'm sure hypothetically you can find a situation, but in this case, it's, you know, we're not dealing with evidence against a defendant, we're dealing with evidence against another witness. And in this case, the unique thing about this case is there's no question that a sexual encounter occurred between the victim and Mr. Kaczynski. He testified that a sexual encounter occurred between him and the victim. The victim actually, a few of her memories that she had left said, I do recall having oral sex with Mr. Kaczynski, and then I think at that point she said she threw up, and it kind of fades out from there. So in this case, it's not a question of if he's the source. This isn't the defendant arguing, hey, I wasn't the one who did this, it was this other guy. This is a case where the other guy's saying, yes, this was a group situation, there were multiple encounters between multiple people. So the question is, in this case, was the appellant also someone who assaulted the victim, TV, I believe, her initials?
So you're saying that the defense in this case is not that the defendant didn't do it, but that he also did it with someone else? That's
No, well, it's not that, hey, it wasn't me, it was this other guy, Mr. Kaczynski. Mr. Kaczynski got up on the stand and testified, yes, I had a sexual encounter with the victim. And then and then after that, the other two deny, or I also don't know how to pronounce her name, and the appellant entered the room, and then they apparently engage in a threesome where the victim is either asleep or passed out on the bed. Before, at that point, the appellant and the victim then separate, and then that's when the other two walk in on them. So the
Counselor,
question,
I'm sorry, let me ask you a question that addresses a point that Mr. Effelman made. If this exact same event had been allegedly perpetrated by the defendant, would it have been admissible as regular similar fact evidence under 9404?
I'm sure the state would have argued it. I believe we would have probably lost, because outside of the fact that
was it admissible?
No, because outside of the fact that there's both sexual assaults, the facts are, there's no similarity besides their sexual assaults. You have one, I mean, they're entirely different charges, you know, physically unable to consent versus sexual assault by threat of force. Here, you know, there's 2 drinks. I think the most testimony was she had 2 drinks, and either she potentially might have, I think there was no evidence that her drink was drugged. It was implied, or potentially that was a possibility. But the victim talks about how she was feeling sick, so it could have been drugs, it could have been something else. There's no evidence of that. But then she hit her head when she went to the bathroom. So she might have had a concussion or some kind of injury there. Versus in the other case with Kaczynski, you have it's one-on-one. He meets the girl at the bar. It wasn't a prearranged meeting between 2 men, 2 women. Takes her back. There was a threat of force. She's crying the whole time, and then he sends her off alone to wash herself. Here, it's a group situation. It's prearranged. I think it was Denier and one of the women and one of the men knew each other, and it was kind of like the other one. They were bringing the roommate, bringing the friend, because I believe it was supposed to be Denier and appellant were kind of the prearranged couple, and then Kaczynski was gonna hang out with TV. So you have completely different situations there. 4 people present. You also have, it turns out to be, they're trading partners throughout the night, consensually or not. And then, importantly, you have the fact that everyone testifies that TV did become violently ill. I think Denier's testimony was she might have been thrown up between 20 to 30 minutes, or sick for 20 to 30 minutes. And at that point, the 2 of them put her into the tub. And I think at this point, they also may have noticed the bleeding. And Denier kind of leads the charge there in washing her. This isn't similar to Kaczynski, potentially with the threat of force, forcing himself onto a girl and then sending her off to wash on her own. This is completely different facts.
When you say, I'm sorry, go ahead, no, please.
When the trial court is sort of considering the similarities and the dissimilarities between the 2 cases, right, and there's the similarities of the alcohol, of the shower,
Right.
and the dissimilarities that we've discussed, how much discretion does the trial court have here?
Well, it's an abuse, I believe for admission of evidence, it's an abuse of discretion standard, so it's, if the trial, it has to be that the trial, no one else besides the trial court would have taken that stance or not. And I think when you look at this, when you compare the two cases next to each other, you'll see that the similarities, outside of being like there was some drinking involved, a lot more in another case, and the fact that it was a sexual assault, big picture, after that, the similarities break down.
Well, what about the striking similarity, or, I guess that's up to the trial judge and us to review, about forcing the victim to bathe afterward, which could affect, the DNA evidence, the availability of DNA evidence.
Right, well, one, DNA was not an issue in this case, but also, forcing her, in one case, he says, go wash yourself off, and apparently leaves her on her own at that. In this case, there was no, forcing her to bathe in the fact that she was passed out and covered in vomit. I admit that, showers involved in both of them, but outside of that, one is a girl who's passed out, potentially bleeding, covered in vomit. Another one is a girl who's been crying for however long, and he sends her off on her own. And also you have Denier involved, and it sounds like she may have been like the one who's doing the actual washing, not, having the victim wash herself. Then when it comes down to it, besides not even being reverse Williams rule evidence, is it even relevant in this case? Because like I said, this isn't a case where someone sexually assaulted the victim and the defendant's trying to say, well, it wasn't me, it was the other guy. In this case, it's did they both do it or not? Pazynski got up on the stand and said, I had a sexual encounter with this woman. He obviously painted it as that it was a consensual encounter. So there's no question that he had sex with the victim. So the question is, not only did he have sex with the victim, but did the appellant also do that? And that's what occurred in the other room. If Pazynski had a separate sexual assault or not is not really relevant to is if the appellant, one-on-one with the victim in the other room, also sexually assaulted her. So before you even really get to the reverse Williams rule evidence, you have to ask, is the fact that Pazynski was charged for another sexual assault more or less likely to make a fact in this case true or not? And again, this isn't what happened in the bedroom when it was Pazynski and the victim, because he testified about that. He got up on the stand, he was cross-examined about that. Everyone knows that happened. It's, did the appellant also, when he took her off to the room and they were off by themselves for 5 or 10 minutes or however long it was before Denier and Pazynski then walked in on her, did he also sexually assault her? And then when you take into the fact of the appellant's text to Pazynski saying, "Oh, she accused me of rape," didn't she? And then also Snapchat or whatever the program of where he was talking about running a train on the victim. It's pretty obvious that he also engaged in sexual relations with her outside of the first encounter when they were on the couch. So if there's no other questions on issue 1, I can move on to a couple of the other issues. Issue 2, on the mistrial, the trial court's pre-trial order was not to mention the virginity or not of the victim. And in this case, the prosecutor, he talks about the hymen and the bleed-in, and where the corrective order came from the court there was not that he mentioned virginity, because virginity being tied to the hymen is a misconception. It was to the bleed-in or not. And then the court was correct in that there was no testimony about the victim's hymen or not. So basically, the prosecutor argued briefly a fact, non-evidence. It was immediately corrected by the court, gave the instruction, and the prosecutor did not mention it again. So this does not rise to the level of mistrial or completely invalidate the trial. And I believe in the appellant's rebuttal argument, he also mentioned the comment about losing her innocence or not. I would mention when you look at the transcript, you'll see that comment was not objected to, so it's an unpreserved error. And also, again, virginity does not equal innocence. Innocence can be any number of things. The fact is, she was a victim of a crime. That by itself could just be used as her innocence. And then appellant conceded that there was circumstantial evidence as opposed to the lift guy, so I think I'll rest on my brief on that one. And then unless there are any other questions or concerns, for the reasons stated today and in my brief, we'd ask you to uphold the appellant's judgment and sentence.
On issue number 4, I do have a question. In terms of whether the victim's consent, was open to sort of cross-examination. What's the state's position in terms of the elements of this crime of sexual battery? Is lack of consent sort of a separate and independent element, or is it kind of subsumed within those 7 conditions?
I would say it's not an independent element because by definition, she was physically unable to consent one way or the other. I mean, in this case, potentially you have that first encounter between the appellant and the victim on the couch where, based on the testimony, it appears that that was consensual. Doesn't matter if she would have potentially consented later on in the evening, once she became physically unable to consent, case closed, if that's what the evidence shows. So here, her understanding of consent or not, doesn't matter, because if she's physically unable,
That makes sense. If she's physically unable to, you could make a strong argument that consent is irrelevant because she's physically unable to as well. But the statute still includes lack of consent as an element to this crime, doesn't it?
I'd have to look at it.
It does. A person 18 years of older who commits a sexual battery upon a person 18 years of older without that person's consent, under any of these conditions, one of them being in this case is guilty of a.
Right. So then I would say it is subsumed because for them to find, the jury has to find that she was physically unable to consent, and if they find that she's physically unable to consent, it follows that she did not consent.
This is a matter of logic.
Like you can't have one finding without the other. And then in terms of harmless error or not, I would say this is similar to recent case law on lesser included offenses. If they had found him guilty of a lesser included offense, potentially it could have been harmful error, but here, because they found him guilty of the actual charge, any lack of the testimony concerning her consent is harmless error because they found her physically unable to consent. Similar to, if I don't read you a lesser included offense, if they find you guilty of the actual charge, any failure to read the lesser included offense is harmless error. If I have any further questions.
Okay.
Thank you for your time.
Thank you, counsel.
So counsel, is the similarity just the fact of bathing, or is it the sexual battery itself? Because as Mr. Welch pointed out, it's a different type. The other one was a threat of force type sexual battery situation, whereas this one was physically helpless to resist. Does that matter, or does it just matter that there was a sex act followed by a request to shower or a shower? That's the similarity, a sex act followed by shower.
I'm not even sure it has to go that far. Again, what the state is asking to put back into the Williams Rule cases involving sexual battery cases is to put back strikingly similar back into it. That has not been the standard since 2011. And there have been thousands of cases statewide.
And that, of course, is presuming that 2C applies.
Well, even under 2A, so let me read what this court said in Whitby. This is a quote, page 232 of the opinion. Regardless of whether the crimes are strikingly similar, under 9404-2A, they are similar enough to support admission under the claim. That similar enough is even under 2A for sexual battery cases. That's what we're looking at. There could have been just a sexual battery period, and I am 100% positive.
Are you saying that because they said similar enough that they rejected the strikingly similar standard?
Yes. The strikingly similar.
Enough, just strikingly similar enough in this context is strikingly similar.
Strikingly similar does not apply to sexual battery cases in Florida anymore. And if you want to go back to because it's 2C, again, if the standard is you have to put, the standard for determining reverse Williams rule is you have to take the other defendant, the defendant in this case, the other person, the defendant's claiming committed the crime, you put that person in the position of the defendant, and therefore 2C applies. And then when 2C applies, I mean, that has to be the way you do it. it can't be that the standard for reverse Williams rule applies as the Posey and the Florida Supreme Court said, unless it's a sexual battery case, and in that situation, the defendant just doesn't get the advantage of 2C. The state still does, but the defendant doesn't. That's not what the Florida Supreme Court
Unfortunately,
said.
that's what the statute says.
But it says that because it's the defendant we're talking about, and the Florida Supreme Court in the 3rd DCA said you take the other person and you put them in the position of the defendant. And when you do that, 2C applies, and therefore that's why it would come in. But putting that aside, it is relevant under 2A. All these circumstances, it's a college-age girl, it's someone who was giving a lot of drinks, it was someone who said there was sex against that person's will. That and alone is similar enough. The shower is certainly similar. Again, there's no question in my mind, if Baczynski had been on trial, the state would be able to introduce the evidence of BB as Williams rule evidence in that trial. If this court adopts the state's position, the state's going to have a much more difficult time in sexual battery cases involving Williams rule from this point forward. That's not what the standard is. Under the current standard, this would come in. And again, under Wisby, when you read Mann, the 4th DCA said, even if it could be said that crimes are not sufficiently similar to be introduced under 2A, the requirements for admission under 2C were satisfied. Of course, that's what we were just talking about. And let me be clear, there was a little bit of confusion. There's only one sexual act we're talking about. Oral sex doesn't matter, digital penetration doesn't matter. There's a charge of sexual intercourse in this case. My client asserts that Mr. Baczynski is the one that engaged in that act. Mr. Baczynski pointed his finger after getting immunity to say it was my client. But that's the only sexual act we're talking about. And I would ask this court to reverse because the trial court erred in not allowing the reverse Williams rule evidence in. Thank you.
Thank you. Thank you to both counsel. This is the last and only case on our docket, so the court is now adjourned.